Hello. Hi, everyone. Welcome. This is the Knowledge Resolution Hub podcast. We are filming, and you'll be able to watch this on YouTube. Some of you may be tuning in audio form. We are here in Oakville, Ontario, and I, Saad Minhas, am here with Rob Pattison.
Good morning. Good afternoon.
Good afternoon.
It's morning somewhere.
How are you doing? Exactly.
I'm outstanding. A little confused about the time, but otherwise.
Night somewhere.
Right? Exactly.
Rob, we are going to have a really great discussion today. I'm quite excited. We know each other.
Yeah.
So for context, Rob and I, we used to work together a very, very long time ago, quite briefly, but at a very similar time for me. As we were talking about earlier, the blessing of the Toronto construction industry is that people know each other quite well.
It's a small world.
See each other around, and so we've had the pleasure of crossing paths many times. So I'm quite excited about today's conversation. I will caveat for anyone who's kind of stumbled upon this podcast, the SEO may throw people off. Saad Minhas talking to Rob Pattison. People might be looking for Hassan Minhaj speaking to Robert Pattinson, the actor. So sorry in advance, but you will learn quite a bit about construction as a byproduct.
I occasionally get calls at home from people who are hoping that I'm the movie star.
Yeah, and you pick up and say, "Hi, I'm Batman."
Absolutely.
Yeah, as you should.
It's a little more, "Hi, I'm Batman."
Excellent. This is why people are confused.
Right? Absolutely.
So, Rob, I think that we want to hear a little bit about you and what you're up to, but I kind of want to start a little bit earlier, and I want to know about your origin story, Batman, and how you found yourself in this industry.
Well, it's an interesting thing. My father was a lawyer, but I never had any interest or intention of being a lawyer. Mm-hmm. When I went to university, I took a course in American politics and history, learned about the Constitution, the First Amendment, constitutional rights, and that got me interested in law. And in fact, when I started law school, the charter had just been implemented, the Canadian Constitution had just been repatriated, and so I set out to be a constitutional lawyer, but it turns out I was not very good at constitutional law. But what I did enjoy was contract law, and I wanted to be a litigator. And so when I articled, which is what we lawyers do as the last step of training before practicing.
Some places known as a training contract or what have you. Yeah.
Exactly. And so when I articled, I focused on litigation, and one matter that I worked on was a construction lien matter. It was a really sort of goofy thing where, as the listeners may know, anybody can register a construction lien when they've performed some work on a project. And that's meant as a security until a judgment. So one where if you succeed with your claim, then the property can be seized and sold. Because that's such a powerful remedy, the courts allow owners or contractors to put security into court to cover the lien so that they can sell or mortgage or do whatever with the property.
Sure.
And a lien claimant was opposing a motion to post security. And it was such a goofy thing. Nobody had ever argued this thing before. And between 5 o'clock one night and 10 o'clock the next morning, I essentially had to learn the entire Construction Lien Act. It's a very policy-based piece of legislation full of pros and cons and balances and so on and so forth. And about 3 o'clock in the morning, I realized anybody who understood the Construction Lien Act would never miss a meal, and except from overwork. And so my course was set.
That's fantastic. That's fantastic. Yeah, I've heard a lot of people cursing the Construction Lien Act, so it's nice to see that there's some that can be grateful to it as well.
It's an interest. It's funny. When I was 35, I was reading there was an article in the Toronto Star about the care and feeding of your lawyer, and how to get the best out of a lawyer. And the article started by saying, "Look, imagine this. You were a great student. You were all around. You're valedictorian. I was none of those things. But you've had this great life, and you come out and you go to law school. You graduate top of your class, and the next thing you know, you're 35 years old, and you're doing construction liens." And I thought, wait a minute, I am 35. I am doing construction liens. And I actually kind of like this work. So yeah.
Yeah, no, not so bad. Not so bad.
Yeah.
So, Rob, tell me a little bit about how you found yourself at Infrastructure Ontario, which is where we met.
Right. So I started my career with a firm called Graham Wilson Green in Barrie, Ontario, 7-lawyer firm. A lot of its work was versus Toronto Council. They had a very sophisticated book of work, as many firms outside Bay Street do. And I ended up becoming active in the Bar Association while I was up there, and ended up moving down to Borden and Elliott, as they then were, in a construction practice.
Now known as BLG, correct?
Now known as BLG, Borden Ladner Gervais, exactly. Spent about 5 years there, and private practice was not for me. I was working myself to death. My blood pressure was 190 over 130.
Goodness.
I ended up going to SNC Lavalin after that, big engineering shop, and did a combination there of front-end work and claims and disputes. And it's interesting because after 8 years of practicing as a troubled projects and litigation lawyer, I remember thinking, I don't know how you could possibly negotiate or draft a contract without understanding what pieces of a contract people are going to fight over and how they're going to approach that fight.
Once you've seen it, you can't unsee it.
Right, exactly, precisely. And it's amazing the things that clients will think will always be fought over that nobody's ever going to fight over, and vice versa. So I did that, and then Infrastructure Ontario was created in 2005. I got a call from them. They were pretty actively recruiting from across the industry. I was employee number 3, and I went over there, and I'd really enjoyed the in-house lawyer role. I got to be an international man of mystery. Went to Australia 13 times in 2.5 years when I was at SNC, but I was ready for something different. And so when I joined IO, I actually left the legal side. I was a recovering lawyer for 12 years. I joined the project delivery group and started in social infrastructure, moved over to transit in 2009. I'm pretty sure I've been responsible for more first-of-kind projects within the IO major project portfolio than anybody else there, and did that for 12 years. And then in 2018, I saw that although the P3 model had been extremely successful and had delivered great results for owners, I saw that we were coming into a period when we were going to see a lot more claims and disputes and aggro. And so I went back to legal, started up what we call the Commercial Resolutions Group, and led that until just about 3 months ago.
That's fantastic. So quick aside here and bit of context. Infrastructure Ontario is an agency of the province. And correct me if I'm wrong, Rob, my memory might be a little bit rusty, but that is the central hub for infrastructure project delivery and project finance for one of the largest holdings in the country, correct?
Absolutely. Infrastructure Ontario is a many-faceted organization. It is the province's largest landlord. It's the province's largest tenant. It is responsible for the vast majority of the province's lands, I think with the exception of those that are owned by the Ministry of Transportation, maybe one or two others.
Sure.
It's a pretty extraordinary organization. It's also a very large bank that lends to the MUSH sector, municipalities, universities, schools, hospitals, and it includes the former Ontario Realty Corp, or the operations of that, and so it's a multifaceted organization with professionals across a bunch of disciplines related to construction, infrastructure, leasing, you name it.
And I would say probably equal parts from the public sector, from the private sector. It attracts a whole range of talent.
Yeah, and in fact
by design.
Yeah, exactly. Yeah. When IO was created, very explicitly the intent was, as the CEO at the time used to say, we're a private company owned by the public sector, and the notion was to bring in people who had experience on both sides of the table, who could go toe-to-toe, both with the asset owners who are on the public side and with the contractors, the consultants, the engineers, the architects, and so on and so forth, and could speak with them knowledgeably face-to-face. And to that end, there was a class of 6 project VPs at the time. I was one of them. Half came from the public sector, half came from the private sector. 2 were architects, 2 were engineers, 2 were lawyers. It was a pretty extraordinary gang, and I learned a lot from them.
Yeah, no, absolutely. I remember, I will say from my experience, being quite fascinated, in fact, pretty obsessed with the idea of IO. I had been a consultant in the construction industry for some time, and looking to do my own legal training. I kind of thought to myself, well, I know I want to practice law. I don't necessarily know whether I want to do it in the way that everyone else has done it. And this place seems to have a really unique mix of all the best projects, a complete fascinating gang of rivals in terms of people that are present and running this operation. But in particular, I do recall reflecting quite a bit on you and your experience there, because you were very atypical in terms of the way that you were functioning at IO, as somebody who was a former lawyer and who was still utilizing, I think, frankly, a lot of the strategic and tactical skills that you learn as a lawyer, but to a commercial end. And I think that particularly when it comes into things like disputes, claims, even, I think, frankly, initiating new projects that there isn't as great a precedent for, it's an incredibly helpful background to have.
Yeah, it's, again, to have fought over stuff, to have understood what will cause friction and what won't cause friction, I found informed a lot of my views and approach. There's kind of 2 sorts of people in the world. I think there's people who look at, try to see what might happen, what can happen, what are the modes of failure that we might encounter, and plan for those and deal with them. And then there's folks who sort of say, they look up, somebody's lifting doing an engineered lift of a grand piano into the penthouse, and it's 40 stories up, and the cable snaps, and they go, well, it hasn't hit us yet. And so I'm one of the former. And look, it's I think it is a lawyer way of thinking. Sure. You look for the problems. But one of the things, and again, I think IO over its history has done a tremendous job of finding people who think this way. It's to ask the question is to be about 90% of the way towards answering it, and to identify the problem is, to be about 70% of the way towards fixing the problem. And, it's funny, early on in my time at IO, I remember turning to Lawrence Quinn, one of the first VPs there, who's very highly respected, really knows his business and seen it all, done it all, born in the log cabin. He helped his father build, he's one of those guys. And I remember saying to him, so project management is basically bad news early. And he said, yeah. Bad news early enough that you can deal with it, right? And so that's the way I was brought up in my time as a project leader at IO.
So I love this, idea of bad news early, and I'm sure Lawrence is probably hiccuping or sneezing or what's the adage, and just hearing this. But I would love to know, just in that vein of being proactive, dealing with claims and disputes, what would you say are among the key lessons that you've learned and taken away?
So this is, anecdotally based on what I've seen over years in my career, not just at IO, and reading the literature about how these projects go. Look, I think there's been some trends in the industry that contribute to disputes as opposed to claims. And we can talk about the difference between claims and disputes. I think that, there's stupid owner behaviors, there's stupid contractor behaviors, there's stupid, consultant behaviors. Stupid owner behavior is thinking you're going to get something for nothing and thinking that a contract is going to solve all of your problems. A smart owner does good due diligence, understands what it is they're asking for, has decided what they want, has decided what they don't want, and has packaged that up and ring-fenced what they're asking for in such a way that they can have a contractor build it, they can have an architect or engineer design it, or they can have a design builder do it all for them. And sometimes, that starts with things like, if you're going to build a school or a jail or a hospital, you want to turn your site into a pincushion. You want to do extensive geotechnical studies. That costs pennies on the dollar of the project cost.
That's an investment.
Right, exactly. It's just an investment. And, the reality is once you're mobbing out to the site with that drill rig, the cost of a few extra holes is nothing. Once you are taking chemical and geological samples, the cost of a couple of extra types of samples is nothing. And, it's very interesting because one of the things I've seen is that a lot of owners because they think short-term, not long-term, don't want to pay for that due diligence. And I think a lot of consultants have gotten used to catering to that market. But again, one of the things we did at Infrastructure Ontario, and again, Quinn, who I mentioned a moment ago, was really in the lead on that, was identifying really good, clear due diligence standards. We know what this site is. As much as possible, project co or contractor, the risks you have to deal with are completely things that you control. And when you can do that, then if you do that well, and if you do it early, you can get a really good price that allows the contractor to build in the appropriate profit contingency risk, so they can just take the risk that they've bought, and complete the project for you and succeed.
Yeah, and on its face, it seems so obvious, right? I mean, these are the risks, the knowns that you can control.
Right.
The upfront items which you can simply take off the table, because the reality is the projects can also be unpredictable. Stakeholders can be unpredictable.
Right.
Certainly, I think with Infrastructure Ontario, there was the additional challenge of the fact that you had ministries who were essentially dictating the scope on these projects, who had, I think, evolving needs is probably the nicest way to put it. And that can pose a challenge as well.
Yeah, I think that one of the we all live in a world that we never made. And one of the explicit reasons that IO was created was because projects were going over budget, over scope, over time, over you name it. And often I think the policy view at the time, as I understood it, was that as long as people realize that the way to get a project built is to break ground or to sign a contract without doing the due diligence, that's what they're going to do. If you require the due diligence to be done to get to that stage of signing the contract, then people will comply. And look, this is something that's not unique to the public sector. It happens in the private sector every day of the week.
I can attest.
Right. Exactly. Right. The reality is you've got the corporation, the board, the government, you name it, who is the money, who's identified the policy need or the corporate objective. You've got the people whose job is to deliver this service, and it's very easy for people to get into that mode of just delivering good news. Yup, everything's going to be fine, fantastic, and then when you discover some things after the contract signed, it's too late to go back. So there's a cliche, and you've heard it a million times, which is fast, cheap, good, pick any two. Well, cheap or being sensitive to cost actually has two aspects to it. One of them is, do I know what the cost is? And two is, how low or how high is that cost going to be? And from a budgeting perspective, in many organizations, it is a better outcome to have an estimate of $1.10 and bring it in for 95 cents than to have an estimate of 80 cents and come in for 95 cents to close the book. And so both of those pieces, and again, I think for a very long time, what we saw there was you could get both a highly predictable price and a really, really good price by opening up the opportunity for bidders to innovate. And my example, again, I'm not an architect or engineer, but wooden studs on 12-inch centers or metal studs on 18-inch centers, like, who cares? Right. Yeah. Let the experts, let the people who are going to have to maintain it for 30 years, as our private sector partners do in DBFMs, let them make those sorts of decisions. Their architects and engineers have the same ethical obligations as the public sectors do, and so we had, I think, great success with that approach.
Yeah, I think it's difficult because, to be fair, particularly in the public sector, there is this expectation where we operate under the expectation that these projects are going to have the same level of instant gratification that people get on their phones, and that's just simply not the way it exists.
Yeah.
I do sympathize with the feeling that, as you said, there's a price that value for money estimate that these projects should cost. And ultimately, in many cases, people, frankly, not only outside the industry, even within the industry, kind of think to myself, I'm confessing, I'm really speaking on my own behalf.
As one does.
Yes. That there's a certain limit in terms of how much things should possibly cost. And, when there are years upon years of change orders and disputes and values are climbing and going through the roof. I mean, at a certain point, do you think that there is potentially something systemic, unique, either about Ontario construction or perhaps even the P3 model?
No. So I happen to believe that a contract is a beautiful and special thing. When you're walking along the street, you have all sorts of legal obligations that just sit on your shoulders without you having any say in them.
Sure.
Right? Regulatory law, criminal law, tax law. You just have to comply. You have no say in it, and that's a wonderful thing. We're a society of laws.
Health and safety, thankfully.
Right, exactly. Yeah. Health and safety, environmental, all of these things that have evolved and have gotten better over the years, and exactly. So not to criticize those, but you don't have a say in those. And then there's things like the law of tort, the duty of care that you owe to everybody. There is a standard of care that you owe when you're driving your car down the street, and if you breach that, and if you crash into somebody, then there's consequences that go along with that. Contract law is an amazing thing because the parties can agree on the deal they want. My example would be, look, let me make you an offer. I will pay you, I don't know, $1,200 or $1,500 a year, and if I choose to get super drunk on cheap tequila and smoke 2 cigars while I'm in bed and I fall asleep and I burn my house down, you'll pay to rebuild my house. And the more expensive my house is, the more you'll pay. Do you want to take that bet?
I mean, how much you're paying me?
$1,500 a year.
No. So the $1,500 a year is the upfront cost. It sounds like there's going to be a lot of change orders on that, Rob.
Right. So you would never take that bet.
No.
But an insurance company does.
Yeah.
Right. So there's this concept of freedom of contract, and freedom of contract is, lawyers often, the sort of cynical view of it is it's the freedom to make a bad deal. But what it really is actually the deal that you'll get rich on, other people won't touch. And so we're allowed to order ourselves that way. And I think, when a contract sets out what our expectations are, it may set out how we're going to track and monitor those expectations. And it may set out what the consequences are of either one of us failing to meet those expectations. Now, which of those don't people like, right? I think it's really, really important that you be able to set expectations. I think the problem that we have in this world is that it's very hard to write a good contract. And human nature being what it is, linguists struggle with this. It's a fundamental communication theory problem. It's a fundamental problem with large language models. We don't have a theory of meaning, right? Yeah. A large language model, when it's doing its work, it replaces geometric proximity between words in the training corpus for meaning. It actually doesn't know what it's writing.
Yeah.
And if you think about it, when you're writing a contract for a P3 contract, any sort of big complex commercial agreement, the first couple of 100 pages are written by the lawyers, and they write as lawyers for lawyers. They negotiate with lawyers. But in fact, a lot of the body of that agreement is going to be read by construction managers, project managers, folks who didn't go to law school.
Yeah, one would hope.
Right, exactly, precisely, exactly. And so, I think it is a reality, and there's organizations that are trying to address this, that most contracts are written for the writer, not the reader. And people of goodwill and good faith can read a contract differently. So if a contract, for instance, says, contractor will do such and such to the reasonable satisfaction of the owner. If you ask a contractor, they'd say, well, yeah, I'll do as much as necessary as long as I'm not going to lose money. And, the owner is going to say, well, yeah, I get to decide on the day if I'm happy. In fact, the court has mapped out some pretty clear delineations of that. If the reasonable judgment is about a matter of engineering or architecture or hydrology or you name it, some professional discipline where most experts in that area or most practitioners would agree within a certain range, then the court will impose that range. If reasonableness is something that's purely taste, you're going to paint me a painting that I like in my reasonable view. The courts are going to be much less likely to interfere in that. And so these words that a lot of people who aren't lawyers will, and even some lawyers will say, well, reasonable, who knows, it's subjective.
Yeah, skim right past it.
Right, they just blow by it. Exactly. And I think a lot of, I think one of the things I've seen throughout my career is that a lot of owners blast through that. They say, well, I'm just going to write this contract that says what I want. It's going to impose a really high standard, and I'm going to have all these folks bid to me, and I'm going to ram this risk down their throat. And this companies around the world do this. This isn't unique to Ontario or Canada. And then what they discover is once that contract is on foot and you're 30, 40, 50, 60% of the way through, the contractor's ability to tell you what you're going to get just flips the script completely. And the owner has all the power formalistically during the bid period, during the negotiation period, when I'm selecting who's going to get there. Once the contractor is in there, the contractor's got a tremendous amount of power. It's very rarely that an owner is going to terminate a contract and come out ahead on money or schedule.
Well, I mean, and it's also reinforced in law. You look at, for example, the contractor's role as the constructor on site. And I think that there are good reasons for that. The reason and the reality that we task contractors with building our projects is because they are able to bear that burden of that risk, because they are able to meet that standard of care, and they are best positioned to apprehend that project delivery. I do, that allusion to, I think, plain language or more simplified contracting, I think it's really, really important. In fact, in my organization, which is a leader in the data center space, we have high volume construction projects, and the approach that we take and that I always reinforce to our teams is really the fact that we are not going to benefit from having ironclad contracts for the sake of it. The reality is that we are sitting here to put together a board game that is accessible and fun, frankly, for both parties to play. And what truly dictates whether the game is won by both parties, one would hope, is whether they actually understand the rules and are able to engage. So fundamental to that is communication and relationships, because obviously there's plenty of things that, frankly, our agreements don't contemplate that happen. And there's ultimately little remedy for, frankly, an owner or a GC or, frankly, a subcontractor that's hell-bent on taking to the ends of the earth to dispute a claim.
Yeah. Yeah. Sorry, go ahead.
I did want to also I wanted to get your thoughts on that and also hear a little bit about how you delineate, you mentioned, between claims and disputes.
Sure. So let's start with the first question, which I've forgotten. Remind me. Okay, let's go to claims versus disputes.
Yeah, answer the question.
Answer the question.
Rob, you can be a politician here. You can answer the question you want to answer.
There you go. Fantastic. So look, there's one of the things to remember is that around the world there's different standards for these things. There's different contracts that define these terms in different ways. For me, a claim is an assertion of rights under a contract. And so if I go to a restaurant and the server hands me a menu and the menu's got prices on it, then I eat a bunch of food, and at the end of the meal, the server puts a check in front of me. That's a claim for payment. And most of the time you go, great, fantastic, add a tip and you're on your way. Sometimes you go, oh, sorry, there's 4 starters here. We only had 3 of them, right? I was once having lunch on a patio with a friend of mine. We were the only table there. It was the first nice day of spring. The poor server wasn't making any money at all, and we both had a burger and a beer. And the check came, and there was a bottle of champagne on it. And we said, oh, sorry, you've got to put that off. And the server looked confused and said, yeah, but it's on the check. Yeah, but you never bought us. So that's a bit of a dispute. Oddly, we ended up having a fight over it. And look, in the ordinary course, there's lots of things on construction projects that are claims and not disputes. Contractor encounters some unforeseeable contaminated soil, and you might have a little bit of a debate or an investigation.
Sure.
Is it 900 meters of soil or 1,100 meters? Is it $100 a yard or $100 a meter or $110 a meter? But that's just due diligence. That's just people doing their jobs. There's other times where you're having a fight over what does the contract say or what did happen. Did you meet that reasonableness standard or some other thing? And there's a legitimate difference of opinion, and both sides think they're right, and they're arguing over it, but they're actually arguing over the thing that they're arguing over. Sometimes those turn into disputes, and they have to be dealt with. A third party has to resolve them on their behalf. And then the third category for me is when one party or the other is having usually some financial difficulties or some other problems performing. This can be the owner or the contractor. And they have to find a way to fill that hole. And often the nature of construction is usually both parties have valid claims at any one time. Those claims might be for a penny rather than a buck.
Yeah.
But nobody is in perfect compliance ever under a construction contract that I've ever seen. There's
Sure.
there's things that come up. And you do have times where one party or the other has lost a buck. They've got an entitlement of a dime or a quarter, and they will try to lever up that buck on the back of that valid claim. And
so let me understand this or repeat this back to you so that I understand this correctly. A claim is essentially as the disagreement, you begin engaging in it, you begin dialogue on it, but once you have passed the Rubicon of an impasse on that claim, it is then that you shift into a dispute posture.
Yeah, I'd bust that up a little bit. I'd say when it's a claim when it's submitted,
Yeah.
There's typically a bit of an evaluation or investigation period. Is this claim valid? Trust but verify. I still think that's in the mode of claim not dispute. Asking open-ended questions. Hey, do you have evidence of this? Do you have timesheets? Do you have borehole logs? Do you have whatever? And then there's the period where you've investigated, you've formed your view, and you either go, right then, fantastic, I'll pay this because it's fully substantiated, which I think, in the world happens probably more often than those of us who deal with claims and disputes think. And sometimes, no, we've actually got a debate now. And, I think the difference between a debate and a dispute is largely maybe one of tone. A dispute is where we've decided, we disagree about something.
Yeah.
And if you, if you think about it, it's interesting because people tend to go into a mode. So, there's a lot of folks, they get a claim in the door and they'll come to legal and they'll say, how do we defend this? And you go, well, wait a minute, have you read it? Maybe it's valid. Maybe let's pay our bills joyfully. And even if there's a piece you disagree with, look, typically for a contractual entitlement, you'll want to know a few things. One, the thing that they say happened, did it happen? The claimant says, I hit contamination, or a worldwide pandemic happened, or you didn't give me access to this land.
Yeah.
Did that happen or did it not? Second, does the contract provide for this thing happening? Lots of contracts in 2020 didn't say anything about a worldwide pandemic.
No, yeah.
And, do you imply something about a pandemic into those contracts under the rubric of force majeure or whatever?
Acts of God, yeah.
Right? Okay, so first, did it happen? Second, is it in the contract? Third, has the party making the claim suffered some sort of impact, whether that's time, money, impact on performance, whatever.
Yep. Damages.
Right, exactly. Fourth, well, it becomes damages if you have the fourth one, which is that impact was caused by the thing that they say happened. And then the fifth is, or what portion of those impacts were caused by it. That would be damages. And then the fifth is, in a contractual setting, did they take steps to reduce the cost of that? Lawyers call that mitigation, as you know. Our audience might not. And those are the elements of a valid claim. And it's amazing to me how often not just clients, but even litigators sometimes go into a mode of, well, once we're fighting about anything, we're fighting about everything.
Yeah.
And in fact, in construction claims and disputes, you don't have the right to remain silent. You are still building the project. You're still creating a record.
Oh, yeah.
You've got to be prepared to say, look, the sun came up yesterday. Yes, I was late giving you access to this piece of property, but you were nowhere near ready to mobilize out there. You hadn't rented a crane. You didn't have any staff on site. You were still putting a schedule together. Don't tell me I delayed you, even though I admit that I didn't comply with the contract. And so often, I think a mistake that parties on all sides of these things make is they want to fight about everything, when in fact you really could narrow the issues and admit a bunch of stuff.
Yeah, and I think part of that maybe also comes from the war stories around these, right? I mean, people imagine disputes as being, all-consuming. That in fact, okay, we're dropping our shovels, we're walking off the job, we are, we're fighting about this to the ends of the earth. We are not doing a single thing until we're paid. And in fact, not only are you paying us for this claim, but guess what? We've got 50 other things that you actually owed us money for this entire time. I think that there does seem to be a little bit less appetite from this anecdotally based on what I've seen in the courts. But I think, frankly, the market finds this very difficult as well, because ultimately, for example, my company operates in many jurisdictions. Typically, we still work in a very localized industry. And ultimately, reputation is king. And it's very, very difficult to be able to continue working with a party that, frankly, is unable to resolve their differences. And I think that ability to bifurcate a particular issue, be, frankly, quite clinical about how you are formulating your claim, submitting it, doing so, meeting the notice requirements and the follow-through that's required up to that claim actually materializes, makes a huge difference, not only to the success of the claim, but actually reputationally.
Yeah, well, absolutely. Look, there's a great book, I think it's called Contracting Strategies for Major Projects by Edward R. Murrow, it looks at data from industrial projects around the world and says essentially, look, the one model that works is where you've got an owner that has a pipeline of projects. And this is hard to solve for, unfortunately, for most owners. Owner has a pipeline of projects, and they've got a stable of 3 or 4 or 5 contractors who they know can do good work and execute these projects well. And yes, there's a contract, but the real control is the owner wants the contractors to perform well, make a decent return, come back next time, and the contractors want the owner to invite them next time. And when you align the interests well, in those cases, what can happen is, even in a case where, wow, we didn't think about something, the contract doesn't give you this, but the contractor is performing well and comes and says, look, I've had this thing come up and it's, $150,000 or $150 million, but here's the receipts owner. People tend to act reasonably in that situation. But there's a lot of owners that don't have the knowledge or experience or governance capability to have those sorts of conversations. And, unfortunately, one of the trends in the industry around the world in the last few years has been leaner owners. There's this asymmetry in the industry.
Yeah.
The owner has the money and the contractor has the expertise.
Yeah.
And that expertise on the contractor side, I think, has taken a hit since COVID to a great extent. But all things being equal, your contractors tend to be more expert in many places and in many industries than the owners. The owner tries to solve for that by just saying, great, I've got this airtight contract. But look, contractors are on very tight margins these days.
Oh, yeah.
And if you're an owner, how are you going to drive down the price? Well, you can buy less. You can build a smaller building. You can have design innovation, metal studs versus wood studs, or things that are more complicated than that. And certainly throughout my time at Infrastructure Ontario, I've seen spectacular innovations that, nobody on the owner side ever would have thought of that would lead to a safer, better, more durable product.
Yeah.
So that can certainly happen. And there's an overlap between design innovation and buying less. If a design, you look at something like Wendy's and Tim Hortons, who now share these sheds where they actually know that most people in the morning are for Tim Hortons. People start coming in, later in the day for Wendy's, and so you build one dining room rather than two, right? That overlaps between buying less and innovating. And then the third is construction innovation, means and methods, and technological things like modularization, or less technological things like just having your act together and having good processes in place. And then the fourth one is I'm just going to beat down the contractor. I'm going to use a competitive process to make them eat their profit, contingency, risk, overhead money. And I think a lot of owners, it's very easy to try to do that fourth one. It's harder, and you can do it because I've seen this. You can do the thing where you use competitive pressure to make the contractors or the project co's come in and innovate on those three things where they can actually deliver a better product for a cheaper price. But it requires knowing what you're asking for and knowing what your lines are. But simply trying to beat down the profit and the overhead, that's a fool's game. And when you do that, the contractor is ultimately going to get their revenge. There's three things I remember from law school, and one of them is don't kick someone when they're down because they will never stay down.
Yeah, of course. I mean, it's also, ultimately, I think you're not going to win by doing so. And I think because there's an expenditure to it, there's a cost to it, irrespective of how that's quantified. I really, really like what you said about innovation. It's one of the things that I wanted to ask you about as well. Is we are seeing massive, dramatic changes because of AI, and not just AI. I think that digitization overall seems to have made leaps and bounds in many industries, but both the law and, frankly, construction have been a little bit behind the ball on this, despite the fact that we're talking about a massive asset class. And, not to knock, there are many service providers and, prop tech and construction tech companies that are really innovating in this space and are getting there. But that mass uptake still has not occurred yet. I think part of it may be the question of we are not fully clear on what the problem set is to address yet. I remember even in 2020, I had written an article on AI usage for dispute resolution purposes. We have courts that are drowning. We have disputes that are protracted constantly. And yet that's certainly something that has not been addressed. What are your thoughts on this, and particularly with respect to claims and disputes?
Yeah, so I think it depends. First of all, are you trying to resolve something on the merits, or are you trying to resolve something based on your interests, or are you just trying to get some money or try to avoid paying money? If we're talking about merits-based or interest-based resolutions where you care about the facts, where you care about what's going on.
Yeah.
I think that artificial intelligence has, or what we call artificial intelligence, has great promise. My view of it is that these tools that fall generally under the umbrella of AI are fantastic for generating options, for going, hey, what's that? For suggesting areas of inquiry, for pointing out patterns you might not have observed. And my understanding is that the conclusion is pretty clear at this point. robot plus radiologist is better than robot alone is better than radiologist alone.
Of course.
Right. And so that sort of stuff is great. I think the real danger for companies and groups looking at adopting AI, if you speak to vendors of AI systems, and you say, well, does your market want to use the robot to replace staff, or do they want to use it to enhance the effectiveness of their staff? I've heard some vendors say 4-to-1 that it's to get rid of staff, it's to eliminate jobs. And look, that's social dislocation and mass redundancy. That's a social problem. Let's put that aside for a moment.
Yeah.
Because actually, look, we believe
Massive
in technology.
implications.
Right, exactly.
Of course.
But so put that aside because, the part of the answer to that is there's always new jobs when the old ones go. We don't have buggy whip factories anymore. So put that aside for the moment. I think there's a real risk, and we're seeing this now already. You and I and anybody in any trade, craft, profession, we started off doing, kind of garbage work that a robot might be able to do.
Yeah.
Right. But you build those muscles, you learn muscle memory, you learn pattern recognition, you learn how things fit together. You struggle late nights over stuff that you look back now and you go, I can't believe that was hard for me because it's so obvious.
Yeah.
But that lets you proceed to the next level of abstraction and the next level and the next level. And so, if you're an accountant, you can look at a spreadsheet and kind of go, what's that? Right. Yeah. If you're a lawyer, you can, it's funny. I had an assistant many years ago who, if one of us ever this was back in the days when most of our files were paper. If one of us ever misfiled something, the other could always guess where it would be misfiled because there's there's only so many things that you can do. I think there's a real risk that rather than treat AI output as an option generator. People are busy, they're overworked, and people are treating the answer as the answer. And, anybody who's ever done this, ask the robot a question you know the answer to.
Yeah.
Ask it a question where you've got domain expertise. You'll be terrified, right? And and so I think that there's a real risk of a lost generation. And then who are those people going to be who can spot that? And we're seeing this with lawyers now. We've now had at least one in Ontario. There have been many of them around the world.
Oh, absolutely.
Right.
Yeah, I think the concerns are absolutely real. The potential use case for it is certainly as an enhancement, as you indicate. I think particularly with the fact that these projects produce an immense amount of data. They produce an immense amount of data, and oftentimes we find ourselves repeating the same mistakes on projects that we know how to build. And so, from a macro standpoint, there is some consideration to, utilizing tools to be able to address that or preempt that. And, going back to the quote you mentioned, it's just really acknowledging those difficult problems early.
Right. And look, I think it's interesting because I've seen organizations who talk about using AI, and I say organizations with an S for real. I'm not talking about an organization. I've seen lots of folks who say, "Oh, we got to bring in AI, and we've got to grind through all of our data." And I look at it and I say, "Well, actually, you can't bear to act on the data you've got." At a certain level, we can give you an Excel spreadsheet and we can create some graphs and we can, before there's all that goofy, those weird intuitions, weird accurate intuitions that the robot can have about some of this data, you're not even engaging with the data you've got. And so, look, this is like anything else. It's a wonder. It may,
it's a tool. It's a tool.
Exactly.
Absolutely.
Exactly. It's like Word. I think that the key lesson of, is it DeepSeek, the Chinese LLM? Look, this is going to be a commodity. it's a commodity product. It has to be, because at a certain point there's not enough energy on the planet to run something that's as bespoke and as baroque as I think some people think AI ought to be. It's going to be a commodity. It'll be like Word. Everyone will use it. It's not going to be anybody's competitive advantage. Like you will.
Nor should it be.
No, exactly, precisely.
Because the thing is, I think the reality is that we all face these challenges, and as a collective, want to see them solved.
Exactly.
So I really like one of the other things that you indicated and the concerns that you indicated around the future of our profession, both as lawyers and frankly for the construction industry, and mentorship in terms of bringing people in. That's something that is very, very important to me, and I think is a huge gap that we see today, because obviously this profession isn't necessarily as sexy as some of the other options out there. Although I will say, I think that, in fact, the construction industry in particular has a pretty strong case to make about being at least late, if not avoiding the fate of redundancy by the technologies we see today.
Yeah. Look, it's interesting. I think, so law in particular, I think it's one of those professions or businesses or things where you either love it or you hate it. And if you love it, we both know a lot of unhappy lawyers, and we both know a lot of super happy lawyers. Like, choose a profession, just who would you like to sit around a dinner table with? If it could be members of only one profession, lawyers, right? Most lawyers are curious, good lawyers. They're curious, they're engaged, they're constantly on the lookout for interesting information. And, there's a lot of lawyers who are great conversationalists. That leads to, I've had great people who brought me up. Brian Jenkins at Kaiser Mason, where I articled, Bruce Reynolds, I'm trying to think of other names. I mean, there's so many.
I'm going to spare you from forgetting any names here, but it's true. There are a lot of people to credit, and I think that investing in young talent is not only important, I think, for our own growth, right? Because obviously, when you teach, you learn. But even beyond that, it is one of those things that that time that you spend, that investment that you put in, can change someone's life.
Exactly.
And I think for us, we all end up as benefactors.
Yeah.
Because this is one of those professions where you see the results of people's efforts tangibly. You experience them. You live in them.
Absolutely. And you do need someone to bring out. The firm I practiced with up in Barrie, when I interviewed for that job, and there were three partners, and one did corp commercial, and one did real estate, and one did litigation and litigation and municipal work. And Marshall, who was the one who wanted to hire me, Marshall Green, I think I'd sold him. The other two partners weren't, they were very serious lawyers, lovely guys. Like, you couldn't ask for better folks to work for. But I come on pretty strong sometimes. And I don't think they necessarily were buying it. And at one point in the interview, John or Tom said to me, well, okay, great, you want to come in and practice litigation. Big part of what we do here is municipal work. And they had a very sophisticated municipal practice there under Marshall. And they said, you don't know anything about municipals, so why should we hire you? And I said, look, I just graduated law school 6 months ago. I'm still in the bar admissions course. The list of things I don't know is so much longer than the list of anything I could possibly know. Yeah. So this is just one more thing I don't know. And that's what got me the job. And I think it's one of the things that put it over the top. And to me, to be a lawyer is to have humility and to realize you are always surrounded by people who know stuff that you don't know.
Of course.
We've got this code of ethics. We've got all of these things that are so important to how, we are the one profession that when you make a mistake or when you believe you've made a mistake, we are obliged to tell the client. I mean, it's an extraordinary privilege and duty that we've got. And you only learn to really internalize that by having people, and Marshall was one of them, and, so many of just these people who show you, here's what it's like to be a professional, here's what it's like to be an adult. And it's a wonderful thing to be brought up by people like that.
No, I think that's certainly something you carry forward with you, and I would really actually love to know about the enterprise you're now building. So tell us a little bit about the new consultancy.
Great, thank you. I still have my ticket. I'm still a lawyer, but I'm actually the firm is called Rob Pattison Consulting for all your Rob Pattison needs.
Nice.
I do have a professional corp, but that's not really what the focus is. I'm providing management advice on primarily troubled project repair, which is where I've spent a huge amount of my career and where I really feel I can add the most value, and pre-transaction due diligence, which is very closely related to that. And really, what I do is provide strategic advice. And help to implement that advice. And when I say strategic, to me, if a decision is not painful, embarrassing, or terrifying, it ain't a strategic decision. And so, much of, as we've been talking about, and as anybody who spent time in this industry knows, much of succeeding over the long term is finding out what your problems are, engaging with them early. What are my weaknesses? What are my unique strengths that will allow me to overcome those weaknesses? And you can do that in a formalistic basis of, well, here's my strengths, weaknesses, opportunities, threats.
Sure.
Okay, sure, great. Unless you actually go, no, here's where I'm failing. Here's where I have a blind spot. Here's where I'm not getting it done. And here's the painful thing that I need to do to change. Anyway, that, and often on construction projects in particular, it means engaging with some of those things early on, or that's the due diligence piece, or when you have these situations we've talked about where projects in the ditch, you've got to complete it. You've got to complete the job. You have to either settle the claims or find a way to ring fence them and park them to be resolved later while preserving your rights, while serving your interests, and in fact, while trying to align your interests with the other party. And it's very, very difficult. I find many, one of the things that I see from many litigation lawyers, commercial litigators, is that they're used to a situation where the event has already happened. You do have a right to remain silent. We know that you never know exactly how the evidence is going to play at trial, and so you marshal it, you be ready to dole it out and to characterize this or that memo or email or fact or statement at the latest possible moment. And again, when you've got a project that's still on foot, you don't have that option. And I think, my experience, and again, this is from my time as a lawyer, my experience is that judges are not impressed by someone who's perfect. Judges are impressed by someone who says, look, here's the thing I did that was right. Here's the thing I did that was wrong. Here's the mistakes I made. And on balance, Your Honor, I'm actually entitled to this thing because I'm looking you in the eye and I'm telling you the truth. I think judges are primates like the rest of us. I say that with every bit of respect because I'm a primate myself.
Tell them, don't worry.
Yeah, no. Well, judges, I think that like the rest of us, when somebody looks you in the eye and says, "Look, here's where I fell short. Here's where I did my job. Here's where I actually sit." That goes a long, long, long way. So that's really the focus. I compare it to the Fram oil filter guy from the 70s. I posted this ad on my LinkedIn page. You can pay me now or pay me later, but ultimately you're going to pay that check and flesh out what the problems are on the project as early as you possibly can, or bring me in if you haven't done that.
I love that. I love that. And by the way, I would absolutely plug Rob's LinkedIn. It is not only a wealth of information and commentary, and I think that, frankly, that candor that works really well in court is also reflected in your LinkedIn, but in a really authentic way, by the way, to not only who you are, but also in a way that people in our industry aren't necessarily as open about. Certainly over a couple of drinks, I'm sure folks are very, very revealing, but it's nice to have that, and I think it's a real benefit to the profession to have that accessible on LinkedIn.
Well, thank you.
So listen, quick rapid fire questions, and then we'll wrap up. Biggest contractor red flag?
Wow. Huh.
Rapid, Rob. TikTok.
Put the contract in the drawer.
That's nice. Excellent. What was your worst project? You don't need to name it, but if you name it, bonus points.
It's funny because I don't think in terms of worst product or project. The reason I like the troubled project work is because I can help. Somebody once said to me, Rob, it's like these troubled projects for you, they're like playing with Barbies. It really is true.
Okay, favorite messy project.
It was the negotiation broke open because I saw somebody's on the other side of the table, saw the eyebrows raise. And somebody couldn't keep a straight face.
Oh, wow. The tell.
Yep. And it was, and what I learned from that and what's true is that very often, there's a difference between what people on a team and, both sides turn into teams. I'm obsessed with group behavior and, you turn into a team. Okay, we're fighting. We're going to win. We're going to beat these folks. And what you tell yourselves is often very different from what you will tell the other party. In my practice, the only thing you can ever tell anybody is the truth. But there's usually debates about, do we settle or not? Do we want to do this or not? And there's usually a constituency for both. And it's amazing how often settlement isn't about beating them into submission. It's about empowering the constituency on the other side of the table so that they can go internally and say, see, here's why this is a sensible thing to do.
Yeah.
Chris Voss, the former worldwide head hostage negotiator for the FBI. Great book, phenomenal book. Never Split the Difference.
That's right.
It's amazing. It's an extraordinary book. And one of the things that he says, and this has always been my practice, but there's people who disagree with this. You should never make an offer that you can't explain. And there's a million cases where, look, if I'm the owner and the claim is $1 billion, the best I'm going to get out of it is of 50 million, and a valid number could be anywhere between 100 and 250, and I might pay 450. Right, that pattern, whether you're fighting over $100 or $10 billion, that pattern replaces itself a lot. And when I say, let's turn it into a buck, you're claiming $1, and I say I offer you a nickel. I have to be able to look you in the eye and say, look, here's why. You've got a weak case and And when I offer you 60 cents, I've got to be able to look to my stakeholders and say, well, that's more than we think it's worth, but a judge could look at it that way and so on and so forth. Sure. I think you've always got to be able to articulate that piece.
Yeah. No, and I think doing so as an exercise is very helpful to yourself. That straight face test.
Yeah.
Can you look at me with a straight face and tell me that this is credible?
Exactly.
Some people are a little bit better at pulling it off than others.
Absolutely true.
Okay, last question. If you were not doing what you're doing today, what would you be doing?
The year I dropped out of high school, flunked out of high school, I was number 4 on the waiting list to go into the radio broadcasting program at Fanshawe College.
Wow. Rob, this entire podcast was basically just a transition point.
And we'll have the weather at the top of the hour.
I love it. All right. I think that's I don't know how I could top that. I think we'll wrap on that. Thank you so
This has
much.
been super fun. Great to see you.
I
so great to see
thoroughly
you.
enjoyed it. Thank you.
Thanks a lot.